This is a broadcast from the YouTube channel, and my new channel is called News from the Peanut Gallery. And we have a guest today, and our guest is an American attorney, an attorney from the United States, from the state of Louisiana. And her name is Christine Mire. And Christine, welcome to our channel.
Hi, Tatiana. Thank you for having me.
Thank you. Thank you for coming. And my question is, today is a little bit lengthy, but can you please bear with me?
Absolutely.
We have this beautiful U.S. Constitution. And in that beautiful U.S. Constitution, we have the 14th Amendment. And in the 14th Amendment, we have the Due Process Clause. And Due Process Clause requires due process of law before a person is deprived by the government of his life, liberty, or property. And as part of that due process of law, what is recognized is a right to impartial judicial review, a federal constitutional right of every American. And my question to you today, Christine, as an expert in that particular area of law, is how easy or difficult for an average American to enforce this federal constitutional right in court. What are the mechanisms? What kind of mechanisms exist to enforce this federal constitutional right for impartial judicial review? Are there any risks involved if a person decides to enforce it?
Yes, when you want to enforce, and I'm assuming you're talking about not just notice. What due process requires is notice, an opportunity to be heard by an unbiased jurist or trier of fact. I am going to just speak to enforcing a non-biased trier of fact. And when you have a judge that you believe has some sort of bias or prejudice, there is only one mechanism in my state that you can utilize in order to enforce that provision, and that is called a motion to recuse that judge. Now, speaking to the second part of your question was, is there any risk associated with that? I think that I have talked to attorneys from all over the country, and I don't think that Louisiana is unique in that it is widely accepted that it is a highly disfavored mechanism among judges.
So can I just please specify one thing? You said that it is the only mechanism to enforce that federal constitutional right, and it is at the same time a most disfavored mechanism, right?
Correct. In my state, I don't know of any other mechanism in which I can ask for another judge if I believe that the judge that I have, for whatever reason, is biased, other than filing a motion to recuse that judge.
So if that is true, if it is disfavored, what kind of risks does a person or his attorney bear when such a motion to recuse is actually filed?
Well, first of all, in my state, up until extremely recently, motions to recuse required actual bias. It required an attorney to prove on behalf of his client that the judge that was actually sitting in front of you was biased, and you had to have proof of bias. Well, that is extremely difficult to prove. So the biggest risk that as an attorney, I advise my client, listen, we need to think very carefully about filing a motion to recuse, because if we lose, we will have to remain in front of that judge who will not at all be very happy with us in the vast majority of cases. So the biggest risk to the client is that if we lose, then, we're still in front of the judge that we have already just attempted to prove was biased. That's a very vulnerable and not favored position for a client or for an attorney to be in. Now, that's one risk that I advise my clients. And of course, I've been practicing for 16 years. So that was the only risk that I was aware of until I experienced it and filed a motion to recuse. Then I became aware of an additional risk to me professionally, in that when I filed a motion to recuse against the judge in Louisiana that I felt very strongly was biased, I was reported to my state bar and disciplinary proceedings ensued for the next 5 years of my life.
Well, I was able to look up certain materials about your case, and I understand that your case has an extraordinary long timeline. Correct me if I'm wrong. I understand that it is in regard of a divorce case, and I understand that the divorce case itself started in 2006. The motion to recuse was filed in 2009. The charges were filed against you, in disciplinary charges, in 2013, and the discipline was imposed in 2017. Is it correct?
That is correct. And I did not finish probation until 2019. So it was a 10-year process for me.
Wow. And may I just ask just one more specifying question? You said that in the state of Louisiana, the only basis allowed to file a motion to recuse a judge to basically enforce, as we talked about in the beginning, to enforce the federal constitutional right to impartial judicial review, they allow the only basis as actual bias. Is it correct?
Well, not technically, Tatiana. We have a statute here that has specific grounds. One is if it's a close member of the judge's family, then we presume actual bias. Okay. If the attorney has recently or is currently representing or was represented by one of the attorneys involved in the case, we presume that's actual bias. And then there's the catch-all phrase, for good cause shown. And the case law up until last year, the case law interpreting that, the vast majority of it said that what was required in order to prove your case for a recusal of a judge was actual bias. That has since changed, but only since last year.
But wasn't there a precedent of the U.S. Supreme Court dating back to 10 years prior, 2009, Caperton v. A.T. Massey call that indicated that an appearance of impropriety is enough?
That is correct. And in fact, we as a state finally implemented that and noted that distinction. What that case says is that if it causes the average person to think that the judge would be unable to hold the lines and not blur it in a nice, true, and correct manner, I think, and you probably know this better, Tatiana, that precise language, but we finally cited that in a Third Circuit opinion in the state of Louisiana, and we have finally accepted the Massey-Cole standard, which has been around for a very long time. But we were a little slow on the draw with respect to implementing that exact language found in that case.
So basically, if you're implementing that standard, then the basis of determining the appearance of impropriety is basically a perception of a reasonable person. Is it correct?
Correct.
Okay. But what kind of motion to recuse did you file, under what circumstances, and why did it end up in the disciplinary committee?
Okay, sort of a lengthy story, but I'll try to make it as brief as possible. My motion to recuse started with a failure to disclose a conflict of interest. In my particular case, the judge had made a very short disclosure about her relationship with the opposing party. In this particular divorce case, which was custody, community property, all those things that go with a divorce, She actually disclosed that her family was close to the wife. I represented the husband, but she still believed that she could be fair and that it wouldn't compromise her judgment. And that was pretty much the extent of our memory of that disclosure. Well, as the case proceeded, my client still did not feel comfortable or that he was being treated particularly fairly. So he did some independent research and he found some additional connections that were alarming to him. The first one was that the judge's son owned a real estate company, and it was named after the name of the judge. And the sister of the wife worked for that real estate company. Well, that was kind of a close connection. Then we found out that the son of the judge was a groomsman for the wife's brother's recent wedding. Again, another close connection. Then we found out that Katie Real Estate was selling some separate property of the wife. She had acquired this property through inheritance, and Katie Real Estate had recently marketed that property. So now we have a situation where the wife is now in business with the son's real estate company. Then we found out additionally that the judge herself had hosted either at her house or at someone else's house, but she was listed as one of the hosts for the wife's brother's engagement party, in which the wife attended. So based on those and a failure to disclose those particular conflicts of interest, and we weren't quite sure how close that connection was. It was a little closer than my client was comfortable with. So based on that, I didn't file the motion. I actually went into chambers and tried to discuss the matter with the judge prior to filing, in hopes that the judge would say, oh, okay, I can understand your client's position, and I'll go ahead and self-recuse. In fact, that's what I absolutely expected to happen, since the judge had already given a previous disclosure. Normally, when a judge gives a disclosure and you say, Judge, thanks for disclosing, we're not quite comfortable, the purpose of that disclosure is so that the judge can voluntarily recuse if anybody's uncomfortable. Well, when we brought it to her attention, she became furious that we were implying that she was not fair or that she had done something wrong. And in this chambers conference, which, by the way, was recorded and is a part of my my disciplinary proceedings, she said she had disclosed everything that we had listed in our motion. At that point, I didn't want to get into an argument over what had happened over the record. So I filed my motion to recuse, and then I requested the transcript of the disclosure.
And what happened next?
So when I asked for the transcript, she quickly sent me a copy of the transcript. Thereafter, I sent a copy of the transcript to my client, and I independently reviewed it. It did not comport with either one of our recollections. That was not at all what we remembered. When the transcript came through, it was the disclosure only. And what my client and I remembered, like a 5-second max disclosure, suddenly became a 2-page transcript. Well, we were pretty certain that all of that wasn't said. So I didn't want to raise any red flags, but I was pretty certain that that was not the way that that it had happened. So I sent the court reporter a request that was very neutral in tone. I'd done it in other cases, in fact, before. And I requested that I be allowed to come into the judge's chambers or come into the office and listen to the tapes that was used to make the transcript. At that point, the court reporter sent back a very defensive email that said, I certainly hope that your request to listen to the tapes is not an indication that I've somehow altered the transcript. Well, this threw me because I had never made an accusation that she had altered. I really just, a very neutral in tone, asked to listen to the tapes. Well, in order to put her at ease again, I responded and said, listen, the request to listen to the tapes is not to check your accuracy. It's to check my own. I have filed a motion to recuse, and I have certain obligations as the officer of the court. And I want to ensure that at no time did I misstate anything in my motion, because I'd have a duty to correct. Plus, now that I'm preparing for a motion to recuse, the tone in which it was said becomes important. I wanted other tapes as well, because we had felt in some of the hearings that she had gotten, she was treating us a little fairly. She had yelled at me in a couple of hearings. She had also indicated in a couple of hearings that I'd misstated things on the record and made the court reporter play it back. She had never done that for any other lawyer, regardless of a mistake was made or not. So I wanted all of those things, not just the disclosure, but all of those things were important in a hearing on a motion to recuse. Well, when I tried to put her at ease, then she said, oh, okay, well, you can't come this week. We have this going on. You can't come next week because I'll be out of town with my son. And she kept prolonging me going in to get to listen to the tape. Well, I did some research and I discovered that at the time, which, by the way, Tatiana, the law has changed on this, but at the time, the recordings used to prepare the transcript was a public record. So I went ahead and you can request a public record in my state by an email, which I'd already done. But in order to make sure that I obtained the tape, I went ahead and issued a subpoena. And certain things that the judge had told me during the course of the proceedings, the court reporter had transcribed other proceedings and she would put off the record conversations. Well, I wanted the recordings also so that I could get the substance of these, quote, off the record conversations. Well, when she said, okay, of course, you can come in and listen to the tape, but you can't come this week because we have a jury trial. Then you can't come next week because I'm visiting my son. And she kept prolonging the date in which I could listen to the tapes, which, by the way, I have a motion to recuse that has since been set for hearing. So I needed these things relatively quickly. So I went ahead and filed a subpoena in order for her to come in and produce the tapes. So I issued a subpoena to the court reporter requesting that she produce the audio recordings used to transcribe the court proceedings. At that point, the court reporter hired an attorney, and that attorney filed a motion to quash the subpoena. And I believe she also filed a request for attorney's fees and sanctions. At that point, the attorney that the court reporter had hired had a conflict of interest, which I sent her an email and said, wait a minute, you have a conflict of interest and you cannot represent the court reporter. She withdrew from the case, and another attorney, a male attorney by the name of Anthony Fontana, got involved on behalf of the court reporter. And in addition to the motion to quash and the request for sanctions, he started sending me very threatening letters indicating that he was going to sue for defamation of character, my client and myself. He indicated that he wanted to sue us.
Oh, wait, can I just specify one other thing? He is trying to sue you for trying to obtain the original media for the transcript, right?
Yes.
Okay, and it was done in a litigation. Does the state of Louisiana have what is called litigation immunity against defamation?
Yes, we do. Attorneys are immune from defamation in the context of their official duties.
And he is still threatened to sue you?
Correct. And my client. And because I have defamation, which you're correct, I have immunity from defamation. I actually said, well, you can't sue my client because he didn't do anything. I was the one that was filing it, and it wasn't as if he signed an affidavit and verified it. So I essentially, as an attorney, stood in front of my client. And then his response was, it doesn't matter. Your client will still not be immune. And essentially, we're going to take you and your client down because you accused my court reporter of criminal behavior. Now, here's the caveat, Tatiana. If you accuse someone of criminal behavior, that immunity does not attach.
Okay. But you still got the media, right? You still got the audio tape, right?
Well, eventually, actually, we had a number of recusals. We have about 11 judges, and several of them recused because they didn't want to hear it. And so finally, we got a judge who did want to hear it. And he said, this is for the protection of the court reporter. If Miss Mire is in fact arguing that the court reporter did something improper, you should want to produce the tapes in order to protect her, which makes absolute sense. I mean, we have a presumption that if people have favorable evidence, they'll turn it over. So he ordered them to turn it over. But more importantly, he ordered that they produce it to a local company that was right across the street from the courthouse. It was a company called ProLegal, and their primary function was to copy legal documents, and they also had the ability to copy this audio recording. So they were supposed to go over to this place called ProLegal, and they were supposed to make, quote, a duplicate of the audio recordings. Well, I wanted to be present, and I kept writing letters to the court reporter that said, let me know when you're bringing it over to ProLegal, because I would like to be present when the tapes are actually copied. So then there's no issue there. I know for my sake of my client what's being done. Well, she didn't do that. I never got the call that she was going to ProLegal. Instead, she went to a Channel 1 video, which is a sound engineers that work there. It's essentially an audio video, more high tech. And they went to a sound engineer there, and they asked the sound engineer to splice together a cassette tape and the actual CD that came from the court reporting equipment. So when I arrived to pick up, I got a call from the sound engineer, and his name coincidentally was Mr. Butcher. And Mr. Butcher contacts me and says, I have a copy of your audio. When we arrived to pick it up, Mr. Butcher says, I'm not going to jail for anyone. I don't know what's going on here, but I've never had this happen. And the court reporter actually produced a cassette tape and a CD and asked me to splice it together. So that sound engineer produces an invoice and wants me to pay for what is described on the actual invoice as audio editing with operator. And
he wanted you to pay for it?
Correct. The court reporter did not pay it. They gave me the invoice. It was like for $100. It was less than $200, but still, the point of the matter is they wanted me to pay for her what was described on the invoice as audio editing.
Okay.
So I asked the sound engineer, well, where did they edit the audio? And he said, well, I could have adjusted it so that you could not hear the difference in audio, but I refused to do that. That didn't feel right. So you can clearly hear the audio editing. And you could. And the edit occurred at the precise moment that my client and I thought that the transcript was inaccurate.
Okay. And so what did you do? First of all, did you pay that invoice?
I absolutely did not. I did not. I declined to pay it and said that they could sue. And they also asked me to pay the court reporter's sitting fee, which I also refused to do.
Okay.
The court reporter also wanted me to pay her a sum of money because she spent an hour with the sound engineer editing the audio. I got an invoice from her attorney asking me to pay her sitting fee as well. And I declined to do that.
Just chasing the last penny, right?
Exactly. So when I got the audio, I started brainstorming with my law partner at the time, and he did some research. He's actually way more tech savvy than I am. He did some research on the audio equipment that was used in the courtroom, and he actually found one of the founders who created the software for these it's called For the Record court reporting equipment. So he contacted him and kind of told him the story and asked why in the world would a court reporter, be using a cassette tape and the CD. And he actually advised of the process. And I ultimately hired him as my expert witness. But the process of actually retrieving the audio is quite simple, and you don't have to leave the courthouse. All that is required is you walk up to the court reporting machine, you drop in a non-readable CD. They require that in order for you to download that audio, it has to be on a CD that cannot be altered. And obviously that's for the protection of the integrity of the record. So all you have to do is put in that CD, and it immediately and very quickly downloads the entire audio for that day. Okay. So there was no need for her to go anywhere in order to splice things together. He also said, because it affected the integrity of his equipment, he also said that he wanted to come in and review the metadata because his equipment only produces what is called proprietary WAV files. These files are done in 5-minute increments so that if the court reporting equipment fails, you'll never lose more than 5 minutes of audio. So he wanted to review the CD that was actually produced by this sound engineer. So he comes to my office and I put in the CD and he looks at the metadata and he immediately backs away from my desk in absolute disbelief and shock. He cannot believe what he's seeing. He said, "Can I have a private moment? I need to contact the coder because I've never seen anything like this." And what he saw in the production of that audio was that the WAV files were there. Some of them had been clipped from their 5 minutes as if something had been deleted. And then he saw a large chunk of data at the beginning where the disclosure was, and that was a Windows media file. His equipment does not produce Windows media file. So he could definitively say at that moment, beyond all doubt, that what I had received did not come from his court reporting equipment in the courtroom, and that audio had in fact been altered, which I already knew because the person who altered told me it was altered. But he could definitively say that it was altered in a number of places.
So altering court records, is it a crime?
It absolutely is. It falls under what we call in Louisiana corrupt practices and malfeasance in office.
Was the court reporter and the judge investigated?
First of all, I would not know. And if the judge was investigated, which I have no knowledge of whatsoever, but even if I did have knowledge in the state of Louisiana, they would have made me sign a confidentiality agreement, and I would not be able to discuss that with you. But I have no knowledge of the judge ever being investigated at all. The court reporter was investigated, and I have no idea what came of that investigation or whether or not she's still a court reporter. She no longer is employed with the 15th Judicial District Court.
But that was in 2009, correct?
Correct.
And wasn't the judge running for elections for an appellate court?
Correct.
At that time?
At that same time, she was running for the appellate court, and she won that election, and she sits on the appellate court to this very moment. And this is her last year, and she will be retiring from the bench in 2020. So there will be a vacancy, and she is retiring because we have a rule in the state of Louisiana that once you reach the age of 70, you cannot rerun for that position. So that is the reason why she will no longer be a judge. It had nothing to do with my case.
So basically your case, if that would become public, that would have hurt her chances to get elected, right? To a higher position.
Well, it did become public and she's still on the bench. So I can't say that.
Okay, but can you just explain to me how was it possible to file disciplinary charges against an attorney who actually caught a stenographer, and that could not have been done without the help of a judge, in actually engaging in criminal activity and producing evidence of that? I mean, usually in cases of judicial misconduct, there is a lack of evidence because people are silent about that. They're afraid to talk, whatever. There are two technical experts who are willing, and I understand they gave testimony about that under oath, right?
They certainly did.
And And despite that, so you were basically turned into disciplinary authorities, and finally, in the long run, you were disciplined for telling the truth and finding out the truth, right?
I was disciplined because of the language that I use in telling the truth. The Office of Disciplinary Counsel, which is our ethics board, took the position that under no circumstances, whether it was true or not, under no circumstances should I have used the language that I used in a Supreme Court brief to describe the actions of the judge. And the language that I used was that the actions of the judge and other officers of the court, which include the court reporter, and there were some other issues with the clerk of court, but those officers of the court were either incompetent and or corrupt. It was that language that was the basis of my disciplinary charges, that I made a false statement against the integrity of a judicial officer.
Excuse me, Christine, but I understand that false statements can only apply to issues of fact, correct? And both words that you used, incompetent and corrupt, are value judgments, don't you think?
Well, I didn't see it that way. I actually remember when I told you that the alteration of court records falls under a statute called corrupt practices. So I didn't see it as a value judgment. I saw it as a legal term. It legally defined the actions that were taken.
So basically, they said that under no circumstances may you use legal terms in a motion to recuse as a basis?
Well, I did it at a Supreme Court brief, and they said that I should not have used that language, and that was the basis of my charges, yes. Okay,
so they are, let's say that they filed the charges. Don't we have a protection under the First Amendment of attorney speech based on the subject of the speech?
I thought we did, Tatiana. However, I raised that argument very early on and continued the First Amendment protection. And that was a very focal point. If you read my decision, it was the essence of my argument. And it was rejected by 4 out of 7 members of the court.
Okay, and that was when? What year?
2000. I think my decision came down in 2015, perhaps.
Okay, so those judges who rejected that in 2015, I understand they didn't read the precedent of the U.S. Supreme Court from 5 years prior, Holder v. Humanitarian Law Project, which says that attorney speech is protected by the First Amendment, and moreover, review of that is subject to strict scrutiny?
They certainly did not apply that standard in my case.
Okay, so they absolutely did not apply strict scrutiny, right?
No, they applied the standard that I needed objective evidence to confirm that the statements that I made were true. And they indicated that I did not have objective evidence to make the statements that I made.
Okay, so what kind of more objective evidence could you possibly have had if you already had 2 witnesses, technical witnesses, testifying?
I'm not sure, because they based the lack of objective evidence on hearsay testimony of the Mr. Butcher, the sound engineer I told you about, who actually spliced the tape. He said sort of a tongue-in-cheek, off-the-cuff comment during his testimony that the court reporter had told him that the reason why she needed to splice the tapes was because there was an equipment malfunction. Now, mind you, the court reporter did not testify in my proceedings, but they used that hearsay statement made by the sound engineer that was not confirmed by the court reporter by independent testimony to say that I knew or should have known that an equipment malfunction occurred, and that is why the tape was spliced.
But didn't you say that the the proprietor of the equipment actually said that there was a Windows media file that could not possibly have been produced by his equipment. Wasn't that objective evidence?
Yes, and they said that is why she spliced it together, because the first 20 seconds of the recording did not record on the court reporting equipment. So she used the first part of her backup method and spliced it together, which my argument was, if she had a backup method, why not produce the entire backup method? She used two backup methods in addition to the court reporting equipment. So if there was a failure, why not produce the entirety of the two backup methods? Why splice anything together at all?
So basically you were accused of defaming a judge. Is it correct? Like in
Yes.
Plain language. Okay. So if you're accused in defaming of defaming a judge, don't we have equal protection of laws, and laws should supposedly to be applied equally to everybody, no matter whether you're a judge or an ordinary person? And that means that if anybody considers himself or herself defamed, then the remedy for that is to actually go to court, file a lawsuit, a defamation lawsuit, and take your chances in how it makes its way through the court. So did the judge actually sue you for defamation?
Absolutely not. And the beauty of defamation is truth is an absolute defense to any defamation charge. Instead, we went through the disciplinary process. She filed a disciplinary complaint against me. And that is when the Office of Disciplinary Counsel took the position that truth was not a defense, that I shouldn't have said it under any circumstances, because I tarnished the integrity of the system by using the words incompetent and or corrupt to describe the actions of the court.
So basically the integrity of the court is maintained by silence?
That is essentially what I gathered from my case, and what I have learned is that I should not have used that language and remain silent about it, essentially. In addition, our rules say that I have a mandatory reporting duty to report anything that I see that another lawyer or judge does. And I use that also as a defense, which also fell on deaf ears.
So, and the judge was still elected and she still sat on the bench. So during your disciplinary proceeding, that particular judge was actually on the appellate bench, right?
That's correct.
I also, when I looked through the certain materials about you, the judge was actually told by the appellate court to recuse, wasn't she?
That is actually a statement that is misstated, I think, in the ABA article. The American Bar Association did an article. The Court of Appeals did not ask her to recuse. She was actually recused by another judge based on a community interest in the 15th Judicial District. She was ultimately recused from my cases, and then she self-recused from all of my cases, ultimately. So I had a total of, I think, 23 recusals against the judge. Somewhere, it was an extraordinarily high number because we only have 2 family court judges. So she started recusing from every one of my cases after she was recused by one of the other judges.
And right now I'm communicating with the Russian legal community, and what they are having there recently, a high-ranking Russian judge has made a statement that courts should not be scandalized. He used that word, scandalized. So basically, what they did to you, they said that under no circumstances, whether it is true or not, may you scandalize, may you say anything corrupt or the word corrupt or incompetent about a judge, about the court. So basically, are judges in this country gods?
They are not. They certainly are not gods, but they certainly have a level of protection, and it is extraordinarily difficult and risky to you professionally to speak ill of the judiciary in any way.
Even if if what you're saying is true.
In my particular case, what I did say was true. However, they indicated that the language I used could not be proven.
Even though it was.
I thought I had proved it, Tatiana. Yes.
So basically, if we go back to my original question, how easy or difficult it is to enforce a federal constitutional right, and not yours, but your client's, for impartial judicial review, it appears to be a kind of an impossibility. So basically, you have to run in circles to actually assert a certain thing to recuse a judge. So to recuse a judge, you must say that certain things that was done by the judge were wrong, right? But at the same time, from the professional point of view, you may not say so, because otherwise you will be disciplined, right?
Well, it's even worse than that. I won my recusal and still got disciplined. I won.
Yeah. And what was the discipline?
I was suspended for a year and a day with all but 6 months deferred, and I was given 2 years of probation.
And during those 2 years of probation, what were the conditions of probation?
That I couldn't engage in any additional misconduct, or the suspended portion of my sentence could be imposed.
Okay, so you could not engage in misconduct, since they considered as misconduct you're doing your professional duties to your client, so you could not effectively represent your clients during that time, right? As a part of professional discipline, right? Probation.
I can tell you that I practice with immense fear and trepidation. That 2-year period is now over, but I can tell you it did affect my professional judgment. That fear of, oh my goodness, will I do this? Will this be misinterpreted? Could discipline be imposed? It was a very nerve-wracking experience. It was something that was so prominent that I felt a duty to disclose it to all my clients on the front end, so that they understood if I said I'm not filing a motion to recuse, they understood why.
Let me ask you this question. You speak about what is called under the First Amendment jurisprudence as chill on the speech, right?
Absolutely.
And basically chill on a professional speech of a lawyer, which is even worse. Don't you think that when we're calling about protection and enforcement of federal constitutional right, and such a fundamental right as a right to impartial judicial review, don't you think that a lawyer should be given, on the opposite, not a straight jacket, but on the opposite, a very wide berth to be able to protect that right, and basically a liberal interpretation of what he's doing, just kind of leniency towards him?
I always thought that judicial integrity would be greater preserved by allowing that leniency, not this enforced silence. That certainly doesn't make people more trusting of the judicial system. And who is in a better position but lawyers to observe that something's not being done properly? So we're in the best position because we have that unique knowledge that the vast majority of lay people don't have. And we are constrained from saying things because out of fear of being disciplined.
That's very sad.
And scary.
And scary. May I ask you a question? If you know, I know, because I know of people who are writing to me from New York, from other states, and they say, we cannot find a lawyer who would make a motion to recuse for us because they tell us that it is a professional suicide. We're not going to do that. Do you know of other attorneys? Do you think that what happened to you put a chill not only on you, but on other attorneys as well, as an example, so that they would not make a motion to recuse too?
Without a doubt. I was told prior to making the motion to recuse that I was committing career suicide. And I was naive, a young lawyer at the time. I'd only been practicing for 5 years at that time. And I would not believe that that could possibly be career suicide, because in my mind, it was doing the right thing. Under the law, my conscience, in every regard, I wholeheartedly believed I was doing the right thing. And I could not wrap my brain around someone telling me that it was career suicide. But it turns out that they were absolutely correct.
Now, let me ask you a question. Well, I'm basing my question on what we have in New York, and I don't know the law of the state of Louisiana. In New York, what we have is, if a lawyer does not make a motion to recuse and does not raise, it is also the only way to actually protect the federal constitutional right for impartial judicial review, and also to preserve the issue of bias, possible issue of judicial bias for appeal, is to make that motion to recuse. So basically, appellate courts say, we're not going to to even look at the issue raised on appeal for the first time of judicial bias unless you make a motion to recuse at the trial level, okay? But at the same time, when you actually do make that motion to recuse at the trial level to preserve that right for appellate review, the lawyer gets sanctioned and gets chilled from doing that. So basically, does that rule exist in the state of Louisiana, that to preserve the issue of judicial bias for the appellate review, you actually must make a motion to recuse at the trial level?
That is correct. And we have an additional component. There is case law in our state that says you have to make it at the trial court level, and you have to make it at the earliest possible opportunity. You cannot wait and see and let the judge issue a decision and then try to get a second bite of the apple. It's been denied just on the basis of timeliness. So not only do you have to make it at the trial court level, you're required to make it at the earliest possible opportunity.
So you're not only mandated, you're rushed, right?
Correct.
Okay. So basically, we have the same thing, and this is New York, this is Louisiana. I've heard the same thing from other states too. Now, let me ask you this question: who decides the motion to recuse? The judge himself?
No, it's referred to another judge in the district court.
Well, thank God for small blessings, because in New York, and I believe in many other states, the judge has to look into his own conscience and review it, and then decide whether his own conscience, which you cannot attach to the record, by the way, tells him that he may or may not proceed, and that's his entire total discretion. So at least in Louisiana, there is a procedure that, another judge looks at it, right?
That's correct. That is correct. We do have that mechanism. The judge cannot decide their own motion to recuse.
Well, that's great. Do you have in the state of Louisiana a right for a peremptory challenge of a judge?
No.
Okay, because some states do have that. I believe at least 18 of them have that.
What is a peremptory challenge? We may call it something differently, because you have to understand, Louisiana is unique in the country. Our law and our terms are very different than other common law states. We're considered a civil law state.
Okay. For example, when you're doing voir dire, when you're picking a jury, you may strike a juror for cause, and you may strike a juror for no cause at all, and you have usually a number of strikes without any cause per statute, right? So this is a strike without cause. And you're striking without cause a juror who is a fact finder. So if the judge is a fact finder, may you do that too?
Only through a motion to recuse, but there are what we call peremptory grounds. And remember, when we started our discussion, I told you what those were. if it's a family member of the court, if the judge has a financial interest in the outcome of the decision, and if the lawyer involved in the case for either side is currently representing the judge. Those are peremptory grounds and automatic recusal. So it would be equivalent to a strike for cause. And then there's the additional grounds, which you have to prove, is called for good cause shown. And it's kind of the catch-all phrase.
I wouldn't call it a peremptory ground because you just said that this is a strike for cause. What I'm talking about is a strike without cause, because some states have a procedure which allows basically judges to be free from having to even be faced with a motion to recuse. A party just comes in and puts in a request for another judge, and that's it, without naming any cause at all.
Oh no, I definitely don't have that. No,
I believe California has such a procedure.
We definitely do not have that in our state.
Okay, but wouldn't you think that such a procedure would save a lot of grief for both sides?
Well, I have a different opinion of that. I think it would encourage forum shopping. And if you don't like a judge, then you put in this cause. So I have mixed feelings about you being able to do that. I think it would delay proceedings and probably encourage like judicial shopping. I think that's just my opinion.
Well, they restrict that. They give you only one strike per proceeding, I understand.
I would find that really aggravating in what I do, because we only have 2 judges that hear family court matters. So it would be detrimental in what I do.
Okay, but with the reality of what you have now, basically, when all attorneys are afraid to file a motion to recuse, which is the only mechanism available. So basically, that means that a certain fundamental federal constitutional right cannot be enforced in the state of Louisiana, right?
Essentially, or it's very difficult for it to be.
So basically, the attorney has to be choosing between 2 duties: duty to his client, which is like a one-time duty. A person comes and goes, right? But it's still a duty to your client, right?
Correct.
And the duty to yourself and to your family, because it's a lifetime investment into your profession, right?
I believe that is absolutely true.
And what should be the resolution of this? What do you think?
I honestly don't know how you resolve that, but I do think one thing that needs to be implemented that I learned from my case, there should be some sort of whistleblower protection for lawyers that truly believe that misconduct is occurring in a case. There needs to be some way where lawyers can be protected if they do report judicial misconduct.
I agree. And there is no such thing in the state of Louisiana?
Absolutely not.
Well, what can I say? So right now, unfortunately, as far as I can see throughout the country, people in the United States are not protected against judicial misconduct, because people who are supposed to protect them, their lawyers, are chilled to the bone. Basically, they are threatened that, they're given a choice, quote unquote. Either they do their duty for their clients, preserve their right for the appellate review, for the review of the issue of judicial bias, or they lose completely their huge, like lifetime investment into the education, into the training, into whatever, and most especially after they are losing license. I don't know what happens in the state of Louisiana, but for example, in the state of South Carolina, they prohibit you, if you are disbarred or suspended, they prohibit you not only not to work as a lawyer, but they prohibit you to work as a secretary, as a cleaner, as a courier, as a driver in a lawyer's office, so that nobody would confuse you with a lawyer. Okay? So basically, you are being not only suspended, you are being deprived of a lot of rights that you actually had before you obtained the license. It's such a big scare that no lawyer would probably file a motion to recuse in his lifetime, don't you think?
I think it would be very difficult, but however, I do still see lawyers doing it. So not often, but like I said, the reason why we had a change in the law with respect to recusals not only requiring actual bias was because there was another brave soul out there that did risk all of that and filed it, and they won, and they were successful in creating a change in the law, which I absolutely respect. But there's no doubt in my mind that it was a scary process.
So there is basically a sacrificial side to practicing law, right?
For me, I felt it very strongly, yes.
Thank you, Christine. It was a pleasure to have you on our channel. Thank you for your sacrifice for your clients, for your sacrifice for the advancement of the rule of law in the country. Thank you very much.
Thank you. That means a lot.
Thank you.